Thank you very much, Andre. I do want to thank Santander and the HEURIGHT and other organizers of this conference, but I think particularly Andre for extending the invitation to me. It is really a genuine pleasure and an honor for me to have this opportunity to keynote what promises to be a highly informative and productive conference on EU Directive 2014-60. I know that I'll learn a lot from all of you. As an American addressing the broad topic of trading and returning cultural objects under international law at this conference, I am certainly an outlier, maybe even a fraud. Unlike most of you, I cannot offer insights drawn from the experience you have within the European system. What's more, I'm from, I think, the only major country and legal system in the world that does not have export controls over cultural objects other than those originating on federal lands and Indian country, Native American lands, and even then only indirectly. And American jurisprudence remains fundamentally hostile to the enforcement of foreign export laws. What has been unlawfully removed and is subject to transnational return, in the words of the directive, therefore requires some adjustment of an American mindset. Finally, from a non-European perspective, the hybrid or blend of constitutional and international dimensions in the EU is always a challenge. Despite, or perhaps because of these infirmities, I was asked to broadly describe the international legal platform upon which the EU directive operates in order to establish a common understanding among all of us, practicing lawyers, government officials, IGO officials, academic experts, and students, so that we're essentially all on the same page in understanding a basic platform. I will then suggest some strengths and weaknesses of the platform, particularly the UNESCO Convention of 1970 against illegal trafficking in cultural objects, and I will conclude by making just a few observations about national initiatives and variations. In the time that I have for my remarks, I'm going to rely disproportionately on examples from the United States and on trading and returning archaeological objects. Three instruments form a sort of tripod, as I see it, of authority to support the platform of international and regional law. These treaties are, of course, the General Agreement on Tariffs and Trade, 1994, the 1970 UNESCO Convention on the Means of Prohibiting and Preventing the Illicit Import, Export, and Transfer of Ownership of Cultural Property, and the 1995 UNIDROIT Convention on Stolen or Illegally Exported Cultural Objects. GATT 1994, as part of the agreement establishing the World Trade Organization, the WTO, has 162 members or state parties at my last count. For present purposes, Article 11 of GATT is fundamental. It prohibits quantitative restrictions, sometimes called quotas, on both the import and export of goods. Import restrictions are more common than export restrictions, as they are customarily applied to protect domestic producers from imports of what are often pejoratively described as cheap foreign goods. Export restrictions, however, are typically employed to protect limited supplies of locally produced goods, or for reasons of national security, and for our purposes, protections of well-being, including cultural well-being and identity. Another important difference between import and export control is that export controls are usually harder to enforce, since most border control stations and so on customarily focus on imports in order to collect duties or to enforce health, safety, and other concerns. Among the exceptions to the prohibition on restrictions of trade in Article 11, however, is Article 20, which allows national measures that are imposed for the protection of national treasures of artistic, historic, or archaeological value. Article 36 of the Lisbon Treaty on the Functioning of the European Union is similarly worded. The precise scope of the term national treasures remains unclear, however. It has never been the subject of analysis by a GATT body of any sort, or WTO panel, or by the WTO appellate body. Indeed, Article 20, in my view, is a sort of legal Lohengrin. Nobody is quite sure where it came from in the absence of any clues in the travaux of GATT, nor, as in the legend of Lohengrin, do we know exactly where the term disappeared in the realm of international law, although there's some evidence that the term national treasures had some resonance in earlier agreements. So the authority to define a national treasure seems to be vested securely in national legal systems. The selection and degree of specificity of national treasures is not always easy to determine. Some of you may have seen a delightful little exhibit in the National Museum here in Warsaw called Anything Goes. I had that opportunity yesterday. It is an exhibit that was put together by 6 to 14-year-old children, and it's really quite charming. One of the sort of mysterious sections in the back is labeled treasures and treasure trove. What was interesting to me was a description, a plaque on the wall that indicated how difficult it was for the children to decide what was a treasure. They pondered it, they had a lot of disagreement, and they finally settled on a remarkable set of objects with scarcely a trace of nationalism. They're from all over the world, really more so in some ways than the National Museum as a whole. And I was quite struck by that experience yesterday, which I'll share with you in the context of trying to figure out what we mean by national treasures. Our second leg of the international law tripod is the 1970 UNESCO Convention. It has 131 states parties, including virtually all of the major art market states now. Although its overall relationship to international trade law remains somewhat imprecise, it is the most important international agreement for cooperation in deterring and responding to illegal trafficking in cultural objects. Sadly, such trafficking is always considered to be the third most lucrative after drugs and arms, amounting to as much as an estimated $6 billion each year by one estimate. Just as sadly, the estimated recovery of illegally trafficked material is a dismal 2 to 5%. A singular achievement of the 1970 convention was the first detailed definition of the term cultural property. Accordingly, it is, as I think most of you know, property which on religious or secular grounds is specifically designated by each state as being of importance for archaeology, prehistory, history, literature, art, or science, and which falls within any of 11 enumerated categories. The 1970 Convention's most important provisions are a system of mutually enforceable export certifications by each state party, in emergency measures for parties to call on each other to prohibit the importation of material from certain specifically identified classes of jeopardized cultural property of special significance, a requirement that parties return property within their jurisdiction stolen from museums, monuments, and other institutions, a requirement consistent with national legislation, is the wording, that parties prevent museums and similar institutions from acquiring property illegally exported from other states, a commitment that parties impose penalties or other administrative sanctions for stipulated violations of a treaty, and a provision for international cooperation in identifying cultural property and developing national inventories. Contraband items are recoverable on demand by the state of origin, so long as just compensation is paid to innocent purchasers. Overall, the convention strikes a compromise between the interests of art importing and art exporting states, to the extent there is a dichotomy, while requiring the importing states' cooperation in the recovery and retrieval of illicitly exported property. The third and last leg of the international law tripod is the UNIDROIT Convention, which has some 37 states parties. Its aim has been to strengthen the regime established by the 1970 Convention by filling gaps that had become apparent in it, particularly involving questions of procedural and private law, such as those related to statute of limitations, bona fide purchasers, and so on. The Convention uses the term cultural objects, which tracks the definition of cultural property in Article 1 of the UNESCO Convention. As with the UNESCO Convention, the UNIDROIT Convention applies prospectively. It therefore does not apply to objects stolen or smuggled into the territory of a state party before the convention comes into force in that particular state. Chapter 2 of the UNIDROIT Convention concerns the restitution of stolen cultural objects. Under Article 3, the term stolen cultural object is expanded to include objects unlawfully excavated or lawfully excavated but unlawfully retained when consistent with the law of the state where the excavation of archaeological material took place. Claims for restitution of such objects expire 3 years after the claimant actually discovers where the object is located and who possesses it. All claims must be made within 50 years from the time of the theft. However, this rule of repose does not apply to objects belonging to public collections, forming part of identified monuments or archaeological sites, or sacred and communally important objects belonging to tribes and other indigenous groups. A party to the agreement can declare, however, that a claim is subject to a generous time limitation of 75 years or longer under its law. Persons required to restitute stolen cultural objects are entitled to fair and reasonable compensation, so long as they are unaware or ought not to have been aware that an object was stolen, and so long as they have exercised due diligence when acquiring the objects. Article 4 identifies factors that apply to the determination of whether the requirement of due diligence is satisfied, such as the price paid, whether the possessor consulted any accessible register of stolen objects, and simply the character of the parties, subject to interpretation. Chapter 3 of the Convention concerns the return of illegally exported cultural objects. Such objects must be returned on the request of a state party to the courts or other competent authority of another state party. Article 5, subsection 3, provides that such a court or other competent authority shall order the return of an object illegally exported if the requesting state establishes that the removal of an object from its territory significantly impairs one or more of several interests. This is an important concession to the art market states, reluctant to recognize source state export controls regardless of their scope. Chapter 3 also includes a statute of limitations and repose provision somewhat similar to those under Chapter 2 concerning the restitution of stolen objects and a distinctive provision for compensation of a possessor. Another paragraph provides for agreements between the requesting state and the possessor of an object, providing for either the possessor's retention of an object or its transfer, either for payment or as a donation to a specifically identified person of the possessor's choice. These three instruments then constitute what I see as a kind of tripod, unstable as tripods sometimes are. Think about a milking stool or something like that. In any event, they constitute a basic tripod of international law to support a platform of other international and regional cooperation and national law for restituting and returning stolen and illegally exported cultural objects, respectively. At the regional level, for example, EU measures on the external export of cultural property outside the EU are, of course, important. But there's much more to the platform of cooperation in the form of bilateral agreements and other multilateral agreements. To take just one multilateral example to which Andre referred in his generous introduction, the 2001 UNESCO Convention on the Protection of the Underwater Cultural Heritage requires its 54 state parties to seize and properly dispose of heritage recovered from historic shipwrecks, cargo, and so on underwater in violation of the convention, and to impose effective sanctions for such violations. So we have to move well beyond the basic multilateral agreements I identified in specific cases that take account of other instruments of this sort. Let me also note that soft law can also strengthen the regime. For example, the principles for cooperation and the mutual protection and transfer of cultural material adopted by the International Law Association in 2006 helped define good stewardship for the caring and sharing of cultural heritage. The instrument's preamble emphasizes the need for a guiding spirit of partnership among private and public actors through international cooperation and is intended to be used by a broad range of interested parties, governments, museums, other institutions, even individual persons and groups of persons. The principles cover 8 topics. First, requests and responses to requests for the transfer of cultural material. Secondly, alternatives to the transfer of cultural material. Third, cultural material of indigenous peoples and cultural minorities. Fourth, human remains. Fifth, requests for return or restitution of cultural material. Sixth, notification of newly found cultural material. Seventh, considerations for effective negotiations concerning requests. And eighth, dispute resolution. So it's certainly a comprehensive document, although it is, of course, soft law. And in helping resolve the dispute, specifically UNESCO's Intergovernmental Committee for promoting the return of property to its countries of origin or its restitution in cases of illicit appropriation, despite the unwieldy name of that intergovernmental body, offers a variety of readily accessible services, including mediation and conciliation facilities. Let me now return to the tripod of treaties and its stability. Regarding GATT 1994, as I mentioned earlier, its national treasure exception to quantitative export controls, prohibition on such controls, appears mysteriously like Lohengrin and then promptly disappears again with little or no formal jurisprudence or guidance by the WTO. Regarding UNIDROIT Convention, I'll gladly defer at this point to Marina Schneider and her expertise. So that leaves us with the 1970 Convention, upon which I'll now focus. Lyndall Pratt, the former director of UNESCO's Division of Cultural Heritage, has observed in her words that the drafting of the 1970 Convention is not entirely satisfactory and has given rise to divergent interpretations. I agree. Let me offer my own specific observations. First on the operational language itself, and then on a broader assessment of the Convention's strengths and weaknesses. I have time to cite just 3 ambiguities in the language of the convention. So let's begin with Article 4, which defines the term cultural heritage to include, among other material, that which is found within the national territory. The phrase found within has been interpreted variously in different legal systems to include, on the one hand, undiscovered material that may be found in the future but has not yet been actually discovered, and on the other hand, only material that has been physically found in the sense of having been discovered or has otherwise come to light. There's certainly room for compromise and eventual consensus in clarifying the language. For example, United States courts have adopted the common law requirement of an immediate right of possession in order to vest property ownership. This might seem to bar ownership claims by other states' parties to undiscovered material, but the common law requirement of actual possession is subject to a recognition of national antiquities laws and judicial decisions of the sort that either expressly vest the ownership of cultural material in a state or imply a delivery of it into possession of a state without any requirement of actual discovery of material under Article 4. Nor under Article 9 of the 1970 Convention, the provision for emergency measures to prohibit importation of certain jeopardized classes of objects. Under Article 9, is there any requirement of actual discovery except in terms of broad categories of objects? A federal appeals court in the United States confirmed this interpretation in a case entitled Ancient Coin Collectors Guild versus United States Customs and Border Protection. The case is full of important procedural rulings that upheld federal seizure and forfeiture of illegally imported coins from Cyprus and China, even though the find spots as the exact geographical origins of the coins were never proven. To be sure, Article 7, B1 of the 1970 Convention limits the prohibition on importation of stolen cultural property or the obligation for that from museums, public monuments, and similar institutions to inventoried material. But there's a good deal of room, I think, for some consensus, some sort of compromise to emerge and further clarification and interpretation of what otherwise is ambiguous language. A second closely related ambiguity in the 1970 Convention involves Article 13's recognition of the inalienability of certain cultural property. But how certain does it have to be? Can a state claim blanket inalienability of all cultural objects that may exist within its territory, or does the word certain limit national claims of inalienability to specifically designated material? It's been a long-standing question. And how mandatory is a state's declaration of inalienability? A lot of questions here. I'm not going to go through all of them in the interest of time, but there would, again, seem to be room for, and there is getting to be some room for compromise and consensus in clarifying the language. Well, how to do it? Well, one example is UNESCO's model provisions on state ownership of undiscovered cultural objects, which was completed in 2012. It forthrightly addresses the ambiguities in Articles 4 and 13 involving undiscovered objects. The model provisions were designed to be brief, approachable, and intelligible. They are so broadly worded, however, that even in the light of helpful commentary, they may be rather difficult to enact without further elaboration or detail, let alone serve to harmonize international custom, given the statutory and judicial variations on the requirements of ownership. It may have been enough to confirm either state ownership or alternatively what may be called a permanent sovereignty, short of ownership, over undiscovered cultural resources, so as to subject them to effective state supervision and regulation. Nevertheless, the model provisions do provide useful guidance for consideration by governments and dialogue between governments. Yet a third ambiguity in the 1970 convention involves the term museum itself, whose meaning has, of course, greatly expanded in the digital era. Also, national laws have otherwise broadened the meaning of the term, at least in specific regulatory enactments. For example, in 1970, as well as in 1983, when the United States became a party to the 1970 convention, the term museum, as used in Article 7A, was generally limited to institutions and other places of exhibition whose acquisition policies were under state control. That has dramatically changed in a number of specific instances. For example, again in the United States, the Native American Graves Protection and Repatriation Act defines a museum very broadly to include all public and private institutions that benefit directly or indirectly from governmental support, even if they have no exhibits or even no organized collections of cultural material. For example, federally guaranteed loans to students in private universities, private institutions, are sufficient to characterize a private university as a museum, whether it actually has a display or organized collection of objects. So-called escape language in the 1970 convention is also of importance to us. Is such language uniformly applied? Does it swallow up obligations? For example, Article 7A, which I was referring to before, imposes an obligation on states parties to take the measures necessary that are consistent with national legislation. And of course, we can all ask, well, how far does the consistency with national legislation go towards virtually trumping any provisions to the contrary in the convention? I hesitate to use the word trump, but in any event, I think you understand I mean it in the original sense. Article 8 offers another example of escape language requiring states parties to undertake to impose penalties or administrative sanctions on irresponsible persons. Does that express only a vague aspiration, or perhaps a good faith commitment to do something somehow, sometime in the future? Or does the word undertake imply a commitment immediately to impose penalties and sanctions? Within a very different context, but very important context, our United States Supreme Court has interpreted the word undertake in the United Nations Charter simply to be aspirational and not to require any immediate. And I don't offer that as a suggestion for the world as a whole, but I do cite it as an example of varying interpretation in different legal systems. Okay, so aside from such unresolved ambiguities, what are the general strengths and weaknesses of the 1970 convention in practice? Its main strengths include most obviously the obligations it imposes variously on states parties. A less obvious strength is its menu of alternatives for international cooperation and adoption as national legislation. Still another strength is in providing a model and a vocabulary for public education concerning the importance of protecting the cultural heritage and in instilling a sense of responsibility in both public and private sectors. This requirement should not be overlooked. As Professor Janet Blake, a leading legal commentator, has observed, in many ways, the institutional and awareness-raising aspects of the 1970 convention have been its most effective elements. As a result, the world takes the problem of illegal trafficking more seriously than it did before the convention. All of the principal art market countries have become parties. It's therefore no exaggeration to identify the convention with the emergence of a new international legal order, rooted more and more, I think we see it as one in human rights, insofar as that order involves cultural heritage. Despite its imperfections and ambiguities, the 1970 Convention has unquestionably shaped laws and decisions of both states parties and non-state parties. It has also redefined public expectations about the role of museums and inspired the preparation of well-respected ethical codes and guidelines. At the national level, a case in point is the adoption of the year 1970 as a uniform effective cutoff date for acceptable acquisitions by institutions whose provenance is insufficiently documented. At the institutional level as well, even unilateral repatriation has become more common. For example, the Denver Art Museum recently returned some 40 wooden totems known as vigangos to Uganda, and what's more, paid for their return. That's a step in the right direction, I think, and it comes, of course, within the legal system that's always been skeptical about export controls. In the words of a prominent museum director, I think sea change is too gentle a word. It's been a landslide change in collecting policy, procedure, and ethics. On the other hand, the principal weaknesses of the convention, as with so many multilateral efforts, is its reliance on good faith implementation by states parties and its lack of capacity for funding national implementation, particularly by developing countries. Another problem has been the lack of national values and ethical codes to support effective cooperation. Currently, aggressive collection and retention of objects in China is a case in point. Still another problem has been inadequate hiring and deployment of trained personnel to supervise controls over trade in cultural objects. Many countries have limited their obligations under the 1970 Convention. It's been cherry-picked by states parties. Japan, for example, confines its treaty obligations under Article 7 to prohibiting the importation of specifically designated foreign cultural objects. As to the United States, I have already noted its hostility to the enforcement of foreign export controls and a reservation to what was to have been a cornerstone, or perhaps still is a cornerstone of the UNESCO Convention for mutual recognition of export certificates. Well, there's been this hostility to the enforcement of export controls, except as they govern property explicitly owned by foreign states, and thereby recharacterizing that property as stolen property. In the United States, 3 articles in the 1970 Convention are paramount. Article 7b, requiring cooperation in the restitution of stolen objects to countries of origin. Article 9, provision I described earlier, enabling countries whose general or particular heritage is in jeopardy to call upon other states to prohibit the importation of certain classes of material. And Article 15, allowing, if not encouraging, bilateral cooperation. Under Articles 9 and 15, bilateral agreements have been effective and increasingly comprehensive. For example, a memorandum of understanding between the United States and Greece restricts the importation into the United States of all archaeological material from the Upper Paleolithic period of approximately 22,000 years ago through the 15th century, as well as ecclesiastical and ethnological material representing the Byzantine culture from the 4th through the 15th century AD. The agreement also encourages the interchange of extended loans, technical assistance in cultural resource management, archaeological permits, and expansion of the registration, monitoring, and enforcement capacities of both countries. It doesn't go so far as to enshrine the concept of co-ownership, which I hope Marc-André Renaud will speak to during this conference. Elsewhere in the world, national models for implementing a convention are remarkably diverse in both letter and practice. Different margins of appreciation and administrative models nevertheless enhance global cooperation. The lack of uniformity in state practices may, of course, be interpreted as either a weakness or perhaps a strength in the sense of more flexibly ensuring state compliance of at least those provisions that they have cherry-picked and are committed to apply. And as well, providing an opportunity for experimentation and comparative evaluation of effectiveness depending upon the particular complex of commitments that a state may have undertaken. Of course, greater uniformity of commitments by states parties and greater agreement on interpretation or ambiguous language in the 1970 convention would help make it more effective. But complete uniformity is perhaps as unnecessary as it is impossible, so long as there are stable expectations about a particular state party's implementation of whatever commitments it has assumed, in openness of governments to expanding their commitments and efforts by UNESCO to achieve greater uniformity, as well as a general consensus on the meaning of terms and qualifying language in the convention. The margins of appreciation among divergent national approaches can help guide international responses and shape the growth of a more effective regime of cultural heritage law. Finally, leaving aside the 1970 convention, it should be noted that legal systems diverge from each other on the scope of export controls and other fundamentals. Witness, for example, the Waverley criteria followed by members of the British Commonwealth of Nations to determine whether to bar the export of cultural objects whose sale price generally in those countries a government is prepared to match. Legal systems also differ on the applicability of controls over privately owned material that is not a national treasure, is not of special significance, or otherwise not a part of the cultural patrimony. Other differences include the definition of significance as a premise for inalienability or limited export controls, the coverage of cultural material of foreign origin, requirements of registration or not, the mechanism of permit and licensing systems, procedures for challenge and appeal of export prohibitions, and the availability of temporary permits for loans abroad. Although claims for the unqualified return of cultural material to countries of origin or rightful owners have met with some success in the courts, the diplomatic arena and the private sector, a trend towards more collaborative solutions, including long-term loans and sharing of objects, is evident. I needn't remind you that in today's troubled world, the focus of cultural heritage law and lawyers has had to shift significantly to the deliberate devastation or dismemberment of monuments and the pillage of cultural objects by terrorists and other armed rebels, often driven by iconoclastic motives and zealotry. Responses to such savagery have included cooperation in creating safe havens for objects and greater attention in broad anti-terrorist initiatives to the protection of cultural objects. States have also enacted emergency measures for the seizure and return of objects originating in zones of armed conflict and looting, such as Iraq and Syria in particular, that would not otherwise be protected under the national laws of the enacting states or otherwise engage the states to take any action. In conclusion, overall, the tripod of GATT 1994, the 1970 UNESCO Convention Against Illegal Trafficking, and the 1995 UNIDROIT Convention on Stolen or Illegally Exported Objects together with numerous other hard and soft instruments, have spurred an increased willingness by national legislative bodies, administrative agencies, and courts to recognize and enforce foreign export controls over designated cultural material and thereby prohibit its importation in many circumstances. The scope of such cooperation, however, is subject to considerable variation among states based on constitutional, legislative, political, and other variables. That may or may not be a good thing. As I've indicated, the returns are probably not in as to whether we should say that's a strength or necessarily a weakness in the variations, the lack of uniformity, and so on. Much more needs to be done, obviously, to strengthen the tripod and to broaden the platform it supports. The European Union initiatives, including Directive 2014/60, are on the vanguard of this effort. Thank you very much.